Good day everyone, we are the reporters for today and our topic is all about court pillar. So what is the legal foundation of the Philippine Court? The foundation of the Philippine Court is provided under Article 8, Section 1 of the 1987 Philippine Constitution. Judicial Department, which states that the judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Supreme Court is responsible for ensuring that government policies are not contrary to law and ensuring that the citizens' legal rights and responsibilities are enforced. What is the scope of judicial power? Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable and to determine whether or not there has been a grave abuse of discretion amounting to lack of excess of jurisdiction on the part of any branch or instrumentality of the government. The regular courts. 1. Supreme Court or SC. The Supreme Court is the highest court in the Philippines. There is only one Supreme Court composed of one Chief Justice and 14 Associate Justices. It is the final arbiter of any and all judicial issues. When so deciding, it may sit en banc or in divisions of 3, 5, or 7 members. Our Chief Justice here in the Philippines is Alexander H. Gismundo. 2. Court Appeals or CA. The Court of Appeals, composed of one presiding justice and 68 associate justices, is vested on jurisdiction over appeals from the decisions of the regional trial courts and certain quasi-judicial agencies, boards, or commissions. Presiding justice is Remedios Salazar Fernando. Court appeal is vested with the power to review all final judgments, decision, resolution, order, or award so of the regional trial court. 3. Regional Trial Courts or RTC. Regional trial courts shall exercise exclusive original jurisdiction in all criminal cases not within the exclusive jurisdiction of any court, tribunal, or body, except those now falling under the exclusive and concurrent jurisdiction of the Sandigan Bayan, which shall thereafter be exclusively taken cognizance of by the latter. 4. Metropolitan Trial Courts or MTC, Municipal Trial Courts or MTC, and Municipal Circuit Trial Courts or MCTC. There shall be created a metropolitan area established by law, a municipal trial court in each of the other cities or municipalities, and a municipal circuit trial court in each circuit comprising such cities and or municipalities that are grouped together pursuant to law. What is the jurisdiction of METC, MTC, and MCTC? Except in cases falling within the exclusive original jurisdiction of regional trial courts and of the Sandigan Bayan, the Metropolitan Trial Courts, Municipal Trial Courts, and the Municipal Circuit Trial Courts shall exercise 1. Exclusive original jurisdiction over all violations of the city or municipal ordinances committed within their respective territorial jurisdiction, and 2. Exclusive original jurisdiction over all offenses punishable with imprisonment not exceeding 6 years irrespective of the amount of fine, and regardless of other imposable accessory or other penalties, including the civil liability arising from such offenses or predicated thereon, irrespective of kind, nature, value, or amount of thereof. Provided, however, that in offenses involving damage to property through criminal negligence, they shall exclusive original jurisdiction thereof. The Special Courts. 1. Court of Tax Appeals or CTA. Court Tax of Appeals exclusive appellate jurisdiction to review by appeal the following: A. Decisions of the Commissioner of Internal Revenue in cases involving disputed assessments, refunds of internal revenue taxes, fees or other charges, penalties imposed in relation thereto, or other matters arising under the National International Revenue Code or other law or part of law administered by the Bureau of International Revenue. B. Decisions of the Commissioner of Customs in cases involving liability or customs duties, fees or other money charges, penalties, seizure, detention, or release of property affected, fines, forfeiture, or other penalties imposed in relation thereto, or other matters arising under the customs law or other laws or part of law administered by the Bureau of Customs under RA number 1125, 1954, Section 7. C. In automatic review cases where such decisions of the Commission of Customs favorable to the taxpayer is elevated to the Secretary of Finance or Section 2315 TCC, and decisions of the Secretary of Trade and Industry in the case of non-agricultural product, commodity or article, or the Secretary of Agriculture in the case of agricultural product, commodity of article, in connection with the imposition of the anti-dumping duty, countervailing, and safeguard duty under Republic Act numbers 8751 and 8752, Section 301, and the Republic Act 8800. 2. Sandigan Bayan. The Sandigan Bayan have jurisdiction over criminal and civil cases involving graft and corrupt practices and such other offenses committed by public officers and employees, including those in government owned by controlled corporations, in relation to their office as may be determined by law. The present anti-graft court, known as the Sandigan Bayan, shall continue to function and exercise its jurisdiction as now or thereafter may be provided by law. CTA's original appellate jurisdiction was expanded to include the following. A. Criminal cases involving violations of the National Internal Revenue Code and the Tariff and Customs Code. B. Decisions of the Regional Trial Courts or RTC in local tax cases. C. Decisions of the Central Board of Assessments Appeals or CBAA in cases involving the assessment and taxation of real property and collection of internal revenue taxes and customs duties, the assessment of which have already become final. 3. Shariah courts. Shariah court are Shariah district courts or SDCs, and Shariah circuit courts or SCCS that were created in 1977 through Presidential Decree 1083, which is also known as the Code of Muslim Personal Laws. These courts have been established to resolve cases involving Muslims. Jurisdiction and venue. Jurisdiction refers to the power of authority given by the law to a court or tribunal to hear and to determine certain controversies. Similarly, the power of courts to hear and determine a controversy involving rights which are demandable and enforceable, while venue refers to a particular country or geographical area in which a court with jurisdiction may hear or determine a case.
So good morning ma'am, I just may am reporting. So this is the continuation of our report entitled The Court Pillar, Venue of Action and Criminal Jurisdiction. Venue is an essential element of jurisdiction in criminal cases. It determines not only the place where the criminal action is to be instituted, but also the court that has the jurisdiction to try and hear the case. So venue or a place, it is an essential element of jurisdiction in criminal cases. Also, it is not only determines the place where the criminal action is to be instituted, but the court also has the jurisdiction to try and hear the case. The reason for this rule has two important parts. First, the jurisdiction of the trial court is limited to well-defined territories such that a trial court can only hear and try cases involving crimes within its territorial jurisdiction. So the jurisdiction or the power to make legal decisions and judgment of the trial courts is limited only to their territories. And the trial court can only hear and try cases involving crimes committed within its territorial jurisdiction. Second, laying the venue on the locus criminis is grounded on the necessity and justice of having an accused on trial in the municipality of province where witnesses and other facilities for his defense are available. So laying the venue or the place in the locus criminis or a place of the crime was committed is grounded on the necessity and justice of having an accused or trial in the municipality of province where witnesses and other facilities for his defense are available. So let's move on to groups of jurisdiction. So there are two groups of jurisdiction, which are criminal jurisdiction and civil jurisdiction. So criminal jurisdiction, it refers to the power and authority to hear cases which are criminal in nature. So criminal jurisdiction is the authority to hear and try a particular offense and impose the punishment for it. So the example for criminal jurisdiction is a federal or state court. Then, civil jurisdiction. So, civil jurisdiction, it refers to the power and authority to hear cases which are civil in nature and not criminal acts. So, civil jurisdiction, in a simple words, a court rights or power to hear non-criminal cases. So, the example for civil jurisdiction is personal injury. So at this point, we are able to tackle the classifications of jurisdiction. So there are 8 classifications of jurisdiction, which are first, general jurisdiction, second, special jurisdiction, third, original jurisdiction, fourth, appellate jurisdiction, fifth, exclusive jurisdiction, sixth, current jurisdiction, seventh, delegated jurisdiction, and lastly, the territorial jurisdiction. So the general jurisdiction, it refers to the power to adjudicate all controversies except those expressly withheld from the preliminary powers of the court. So, general jurisdiction, in a simple words, a court's authority to hear any type of case which is not vested in other courts. So, the example for general jurisdiction is the criminal case, civil cases, and family cases. Second is special jurisdiction. Special jurisdiction, it refers to the power that restricts the court's jurisdiction only to particular cases and subjects to such limitations as may be provided by governing the law. So courts which have the power to hear only the certain types of cases or are clothed with special powers for the performance of specified duties beyond which they have no authority to any kind. So example for this is Sandigan Bayan. So the Sandigan Bayan is a kind of special court set up to deal with instances or corruption involving a government official or an official in a government-owned body, and it also has jurisdiction over other crimes committed by public officials if these felonies related to their office. Third, original jurisdiction. So original jurisdiction, it refers to the power of the court to take judicial cognizance of a case instituted for judicial action for the first time under conditions provided by law. So original jurisdiction, a court's power to hear and describe a case before any appellate review. A trial court also must necessarily have original jurisdiction over the types of cases it hears. Example for original jurisdiction is state and local courts have original jurisdiction over matters involving residents of the state. Fourth, appellate jurisdiction. Appellate jurisdiction, it refers to the authority of the court higher in rank to re-examine the final order, judgment, or lower court which tried the case now elevated for judicial review. Appellate jurisdiction, the power to reverse or modify the lower court's decision. Appellate jurisdiction exists for both civil and criminal law. Example for appellate jurisdiction is the Supreme Court. The Supreme Court consists of a Chief Justice and 2 associates and has appellate jurisdiction chiefly. Fifth, exclusive jurisdiction. Exclusive jurisdiction, it refers to the power to adjudicate a case or proceeding to the exclusion of other courts at that stage. So exclusive jurisdiction exists when only state courts or only federal courts have authority to hear a case. Example, for offenses against our law, which are not offenses against the law of the visiting army, our courts have exclusive jurisdiction. Sixth, concurrent jurisdiction. So concurrent jurisdiction, it is sometimes referred to as the coordinate jurisdiction, which is the power conferred upon different courts, whether of the same or different ranks, to take recognizance at the same of the time case in the same or different judicial territories. So concurrent jurisdiction exists when two different courts have authority to hear the same case, and also it gives two courts equal authority to hear and decide a case. So an example for concurrent jurisdiction is a civil case involves or opposing parties from different states. Seventh, delegated jurisdiction. So delegated jurisdiction, it is refers to grant of authority to inferior to hear and determines cadastral and registration cases under certain conditions. 8 is territorial jurisdiction. So territorial jurisdiction, it refers to the geographical area within which its power can be exercised. So territorial jurisdiction, it is the court's power to bind the parties to the action. This law determines the scope of federal and state court power. Example for territorial jurisdiction. A state maintains jurisdiction over its citizens when they are overseas, and where certain criminal offenses can be prosecuted in a state regardless of where they committed. Example for territorial jurisdiction is child sex offenses. So, territorial jurisdiction refers to the geographical area within which its powers can be exercised, such as A. MTC, B. RTC, and C. SC or CA. So, A. MTC or Municipal Trial Court. It is within the municipality or city where it is located, as may be defined as SC or Supreme Court. So MTC or Municipal Trial Court, a court that is sits in some cities and larger towns that usually has civil and criminal jurisdiction over cases arising within the municipality. B. RTC or Regional Trial Court. Regional Trial Court shall exercise appellate jurisdiction over all cases decided by metropolitan trial courts, municipal trial courts, and municipal circuit trial courts in their respective territorial jurisdiction. And SC, Supreme Court, and CA, Court of Appeal. Supreme Court and Court of Appeal. A Supreme Court is the highest court within the hierarchy or courts in CA, is vested with the power to review all final judgment or decisions. So at this point, we're in classification of court according to jurisdiction. So there are 9 classifications of court according to jurisdiction. First is Court of General Jurisdiction. So those competent to decide their own jurisdiction and to take cognizance of all kinds of cases except those expressly withheld from the plenary powers of the court. So Court of General Jurisdiction signifies that they can handle almost any type of controversy, though in fact they may not have jurisdiction over certain types of cases assigned to specialized tribunals. Example for Court of General Jurisdiction is immigration cases. Second, Court of Special or Limited Jurisdiction, those which have no power to decide their own jurisdiction and only try cases permitted by statute. So, Court of Special or Limited Jurisdiction. A court or limited jurisdiction has authority to hear and decide cases only of a particular subject matter. Third, Court of Original Jurisdiction, those which under the law, actions or proceedings may originally be commenced. So, Court of Original Jurisdiction, a court's power to hear and decide a case before any appellate review. Fourth, Court of Appellate Jurisdiction, those which have the power to review and appeal the decisions of orders of our lower court. So, Court of Appellate Jurisdiction, the power to reverse or modify the lower court's decision. Fifth, Superior Courts, those which have the power of review and supervision over another or lower court. Superior Courts, a law court that deals with serious or important cases. Sixth, Inferior Courts, those which in relation to other courts are low in rank and subject to be reviewed and to be supervised by the latter, as used in 1987 Constitution. The term inferior courts refer to all courts lower than Supreme Court. So inferior courts, these courts often staffed by part-time judges who are not necessarily trained in the court. 7. Court of Record. Those whose proceedings are enrolled and which are bound keep a written record trials and proceedings handled by them. Republic Act 6031 mandates to MTC to be a court of record. Thus, courts not of record no longer exist. 7. Court of record means a court whose proceedings, acts, and decisions are all kept on a permanent record. 8. Constitutional courts, those which owe their creation and existence to the Constitution and therefore cannot be legislated out of existence or deprived by law of the jurisdiction and powers unqualifiedly vested in them by the Constitution. Example, SC and Sandigan Bayan. So, Constitutional Court, the highest court in the country when it comes to the interpretation, protection, and enforcement of the constitutional. Lastly, statutory courts. Statutory courts, those created, organized, and with jurisdiction exclusively determined by law like CTA. So, statutory court has jurisdiction over all causes and proceedings, civil and criminal, original, and appellate prescribed by law for courts. So, we're in the what is the doctrine of hierarchy of courts. So, it is an established policy that the parties must observe the hierarchy of courts before they can seek relief directly from the Supreme Court. So, the rationale for this rule has twofold. First, it would be an imposition upon the limited time of the Supreme Court. B. It would be inevitably result in a delay intended or otherwise in the adjudication of cases, which in some instances had to be remanded or referred to the lower court as the proper forum under the rules of procedure, or as better equipped to resolve the issues because the Supreme Court is not a trier or fact. So what is the doctrine hierarchy of courts? So, direct recourse to the Supreme Court is allowed only to resolve questions of law, notwithstanding the invocation of paramount or transcendental importance of the action. The basic court system in the Philippines. In the Philippines, the regular courts engage in the administration of justice is organized into 4 levels. So it is Supreme Court, Court of Appeals or CA, Regional Trial Courts or RTC, and the Metropolitan TC or MDCC and MCTC. So the Supreme Court and Court of Appeals or CAs is under the revised court, while the Regional Trial Court or RTC and the Metropolitan TC and MTCC and MCTC is under the trial court. Supreme Court. So, Supreme Court has Court of Appeals and Sandigan Bayan. Then, Court of Appeals has Court of Tax Appeals, Regional Trial Courts, and Shariah's District Courts. Then, Regional Trial Courts has Municipal Trial Courts in cities, Metropolitan Trial Courts, Municipal Trial Courts, and Municipal Circuit Trial Courts. Then the Shariah's District Courts had Shariah Circuit Courts. Then the special courts here are Court of Tax Appeals, Court of Appeals, and the Sandigan Bayan. Then the regular is the Regional Trial Courts, Shariah's District Courts, Municipal Trial Courts in cities, Metropolitan Trial Courts, Municipal Trial Courts, Shariah Circuit Courts, and the Municipal Circuit Trial Courts. That's all. Thank you.
Hello ma'am, I am Jara Kim Arojado and this is the continuation of our report. What is the doctrine of adherence of jurisdiction? The principle that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do in the exercise of that jurisdiction. The doctrine holding that even the finality of the judgment does not totally deprive the court of jurisdiction over the case. What the court loses is the power to amend, modify, or alter the judgment. Even after the judgment has become final, the court retains jurisdiction to enforce and execute it. It is also called doctrine of continuity of adherence. This principle states that once a court acquires jurisdiction over a courtesy, it shall continue to exercise such jurisdiction until the final determination of the case. This principle also means that once jurisdiction has attached, it cannot be outsaid by subsequent happenings or events. So we will proceed to lesson 2, the court as the third pillar of CJS. The roles of the court in the criminal justice system. A. Determines the probable cause for the issuance of search warrant of arrest. This is where the court will determine if there is a fair probability that contraband or evidence of a crime to issue a warrant of arrest. B. The protection of the rights of the accused during trial. This is where the court protects defendants, example from being forced to reveal incriminating facts. This is also include a fair trial and due process. C. Grants bail to the accused if qualified. Bail may be given in the form of corporate surety, property bond, cash deposit, and recognizance, and fulfill other conditions. D. Conducts arraignment and plea. This means the formal appearance of an accused person to hear and to receive a copy of the charge against him or her in the presence of judge. E. Conducts pre-trial. F. Conducts trial. G. Pronounces judgment. It is also the final decision in a criminal trial. H. Consider a new trial or reconsideration. At any time before a judgment of correction becomes final, the court may, on motion of the accused, oral its own instance, but with the consent of the accused, grant a new trial or reconsideration. And I. Consider appeal. Appeal is the legal process to ask a higher court to review a decision by a judge because you believe that the judge made a mistake. Hence, these succeeding are the basic concept only in connection to the roles of the court in criminal trial. First, probable cause of the issuance of search warrant. The task of the court in connection to the criminal justice system starts the moment the law enforcement pillar seeks for the issuance of search warrant. In reiteration, a search warrant is defined as an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. So reiteration means the offender has previously punished for an offense to which the law attaches an equal or greater penalty, or for two or more crimes to which it attaches a lighter penalty. What are the requisites of the personal examination that the judge must conduct before issuing the warrant? A. The judge must examine the witness personally. B. Examination must be under oath. And C. Examination must be reduced into writing in the form of searching questions and answers. To conclude, the judge must before issuing the warrant personally examine in the form of searching questions and answers. In writing and under oath, the complainant and any witnesses that he may produce and attach to the record their sworn statements together with their affidavits submitted. Hence, before a judge issues a warrant to any law enforcement agency applying for it, he or she has to satisfy himself or herself of the probable cause. Clearly, it presents the relationship of the law enforcement pillar with the court pillar. Second, the probable cause for the issuance of warrant of arrest. In the issuance of warrant arrest, the judge similarly performs his or herself role on the determination of a probable cause based on the complaint or information filed before him or her. Hence, a warrant of arrest is issued in the following manner. A. Within 10 days from the filing of the complaint or information, The judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. B. He may immediately dismiss a case if the evidence on record clearly fails to establish probable cause. C. If he finds probable cause, he shall issue a warrant of arrest or a commitment order in the accused has already been arrested pursuant to a warrant issued by the MTC judge who conducted preliminary investigation or when the complaint or information was filed. The case of Pangay v. Ganay modified this rule by providing the investigating judges the power to order the arrest of the accused is limited to instance where there is necessity for placing him in custody in order not to frustrate the ends of the justice. D. In case of doubt on the existence of the probable cause, the judge may order the prosecutor to present additional evidence within 5 days. From notice and the issue must be resolved by the court within 30 days from filing the complaint or information. E. Warrant of arrest is issued by the MTC and the preliminary investigation was conducted by the prosecutor. The same procedure as the above followed. This presents the relationship of the three pillars of the criminal justice system, namely law enforcement, prosecution, and court. When warrant of arrest not necessary. A. When the accused is already in detention issued by the MTC. So MTC is the Municipal Trial Court. B. When the accused was arrested by virtue of warrant. So if the arrest is by virtue of warrant, it means that there is already a case filed in the court. C. When the penalty is of a fine only. This is a penalty of money that court of law or other authority decides has to be paid as punishment for a crime or other offense. D. Those covered by summary procedure. So summary procedure is defined as procedures applied to settlement of a civil case that meet all the conditions prescribed by the Code of Civil Procedure in a simpler sequence than the procedure for the settlement of ordinary case. 3 situations of finding a probable cause. First, probable cause in filing an information or complaint. It refers to the facts and circumstances that would engender a well-grounded belief that a crime has been committed and the person to be charged is probably guilty thereof. This is done during the conduct of preliminary investigation. Second, probable cause is the issuance of warrant of arrest. It refers to the facts and circumstances that would lead a reasonable, discreet, and a prudent man to believe that there has been a crime committed and the things and objects connected to the crime committed are in the place to be searched. Third, probable cause in the issuance of warrant of arrest. It refers to the facts and circumstances that would engender a well-grounded belief that a crime has been committed and the person to be arrested committed it, or facts and circumstances that will lead a reasonably discreet and prudent person to believe that an offense has been committed by the person sought to be arrested. Note: the determination of probable cause in filing information is the function of the prosecution, while the determination of probable cause for the purpose of issuing search and warrant of arrest is the duty of the court. It is the judge alone who determines the probable cause for the issuance of warrant of arrest. It is not for the provincial fiscal or prosecutor to ascertain. Determination of the probable cause, a judicial and executive function. First, executive function. It is an executive function if the purpose is to determine whether there is a reasonable ground to believe that the accused has committed the offense and should be held for trial. Second, judicial function. It is a judicial function if the purpose is for the issuance of warrant or search warrant. Since the objectives are different, the judge shouldn't rely solely on the report of the prosecutor in finding probable cause to justify the issuance of warrant of arrest. And that ends my report. Thank you.
So good day everyone, my name is Rex Marmorato, one of the reporter of Group 3. So today I will discuss my part. Distinction of probable cause of prosecutor from that of a judge. A. The determination by the prosecutor of probable cause is for the purpose of either finding information in the court or dismissing the charges against the respondent, which is an executive function. The determination by the judge of probable cause begins only after the prosecutor has filed the information in the court. The determination of probable cause is to issue an arrest warrant against the accused is a judicial function. So, in the first explanation, it says that probable cause for a prosecutor is they need to establish a reasonable basis to believe that a crime occurred and the accused person is connected to it. This standard is used to initiate criminal charges against a suspect. B. Probable cause to hold a person for a trial refers to finding of the investigating prosecutor after the conduct of preliminary investigation that there is a sufficient ground to hold a well-being founded belief that a crime has been committed and that the respondent is probably guilty thereof and should be held for trial. Based on the finding, the investigation prosecutor files the corresponding compliant of information in competent court against the accused. The determination of probable cause is to issue a warrant of arrest is a judicial function. A judge cannot compel to issue a warrant of arrest if he or she believes honestly that there is no probable cause for doing so. So it says in B that probable cause for a judge is they review the evidence presented by the prosecutor to ensure that there is a reasonable basis for the charges. This standard is used to authorize actions like issuing search warrant or making an arrest. In summary, prosecutor use a probable cause standard to decide whether to bring charge against someone, while the judge use it to determine whether there is enough evidence to proceed with legal actions like issuing warrants or making arrest. Next is criminal process in court. Number 1. Rights of accused during trial. In all criminal prosecution, the accused shall be entitled to the following rights. A. To be presumed innocent until contrary is proven beyond reasonable doubt. B. To be informed of the nature and cause of the accusation against him. C. To present and defend in person and by the counsel at every stage of the proceedings, from arrangement to promulgation of the judgment. The accused may, however, waive his presence at the trial pursuant to the stipulation set forth in his bail, unless his presence is specifically ordered by the court for purposes of identification. The absence of the accused without justification cause at trial of which he had notice shall be considered a waiver of his right to be present threat. When an accused under custody escapes, he shall be deemed to waive his right to be present on all subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in persons when insufficient appears to the court that he can properly protect his rights without the assistance of the counsel. Letter D. To identify as a witness is in his own behalf but subject to examination on other covered by direct examination. His silence shall not in any manner prejudice him. E. To be exempt from being compelled to be witness against himself. F. To confront and cross-examine the witness against him at the trial. Either party may utilize as part of the evidence the testimony of witness who is deceased out of cannot with due diligence but found in the Philippines, unavailable or otherwise unable to testify. Given another case of proceedings, judicial or administrative, involving the same parties and subject matter, the adverse party having the opportunity to cross-examine him. G. To have compulsory process issued to secure the attendance of witness and production of other evidence in his behalf. To have speedy, impartial, and public trial. To appeal in all cases allowed and in manner prescribed by law. So criminal process. So that is a criminal process. So criminal process in court refers to the legal procedures and actions that takes place within the criminal justice system when a person is accused of committing a crime. These processes are designed to ensure fairness, protect individual rights, and determine the guilt of innocence of the accused. While the specific details can vary by jurisdiction, the following are some common elements of the criminal process in court. It's important to note that the criminal process can vary significantly depending on the jurisdiction and the nature of the crime. Are the rights of a person under custodial investigation and the rights of the accused at trial the same? The answer is no. To inform the rights of a person under custodial investigation is a duty incumbent of arresting officer to arresting officer or officers, which is known as Miranda warning. Every suspect arrested is entitled to such as, while the rights of accused at trial is literally referring to rights being observed in the court during trial. All the accused are entitled to such rights. So the rights of a person under custodial investigation and the rights of the accused at trial share some similarities, but they are not exactly the same. Some of their differences are the right to be informed, protection against self-examination or incrimination, protection against unlawful searches or seizures, presumption of innocence, right to confront witnesses, and the right to present a defense. Number 2 is right to bail. Bail is a security given for the release of a person in custody of the law, furnished by him or a bondsman, to guarantee his appearance before any court as required under the condition hereinafter specified. Bail may be given in the form of cooperate surety, property bond, cash deposit, or recognizance. Right to bail protect the right to bail protect the presumption of innocence, which means that a person is considered innocent until proven guilty. It allows individuals to be released from jail and continue their normal life, such as going to work, taking care of their families, and taking care of their family while their case is pending. However, it's worth noting that in some cases, such as when a person is considered a flight risk or a danger to the community, bail may be denied or set a very high amount. This is done to ensure public safety and prevent the accused person from evading justice. Next is conditions of the bail. A. Undertaking shall be effective upon approval and unless cancelled, shall remain in force at all stages of the case until promulgation of the judgment of the regional trial court, irrespective of whether the case was originally filed in or appealed to it. B. The accused shall appear before the proper court whenever required by the court. C. The failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to present the threat. In such case, the trial may proceed in absentia and the bondsman shall surrender the accused to the court for execution of the final judgment. The original paper shall state the full name and address of the accused, the amount of undertaking, and the condition required by this section: photographs, passports taken within the last 6 months, showing the face, left and right profiles of the accused must be attached to the bail. So the conditions of the bail are rules set by a court that a defendant must follow while they are released from custody before their trial. These rules are designed to ensure that the defendant attends all court appearance and does not commit any further offense while they are on bail. So the phrase here says that no release or transfer except on court or bail. No person under detention by legal process shall be released or transferred except upon order of the court or when he is admitted to bail. So in essence, the phrase emphasizes that the person's freedom of movement is restricted unless authorized by a court order or if they meet the conditions for bail. This provision is often implemented to ensure the individuals facing legal proceedings are not able to evade justice or pose a risk to public safety by being released or transferred without proper authorization. So next is bail as matter of right. All persons in custody shall be admitted to bail as a matter of right, with sufficient sureties or released on recognizance as prescribed by law or this rule. A. Before or after conviction by the Metropolitan Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court, and B. Before conviction by the Regional Trial Court of the offense not punishable by death, reclusion perpetua, or life imprisonment. Bail is a matter of right refers to the legal principle that allows an accused person to be released from custody pending trial without need to provide exceptional circumstances or meet specific criteria. It ensures that individuals are not subjected to unnecessary pre-trial detention and preserves the presumption of innocence. But note that we must strictly follow the law or this rule. So, what is recognizance? Recognizance is a mode of securing the release of any person in custody or detention from the commission of the offense who is unable to post bail due to objective poverty. The court where the case of such person has been filed shall allow the release of the accused on recognizance as provided herein to the custody of a qualified member of the barangay, city or municipality where the accused resides. So recognizance is a legal term that refers to a court order requiring an individual to fulfill certain obligation of restriction, typically in connection with pending criminal charges or as a condition of bail. It is a promise of commitment made by the person to the court, and failing to comply with the conditions can result in legal consequences. It is important to note that the specific condition of recognizance can vary depending on the jurisdiction and the circumstances of the case. Next is bail when discretionary. Upon conviction by the regional trial court of the offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. The application for bail may be filed and acted by the trial court despite the filing of notice of appeal, provided it has not transmitted the original record to the appeal court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed when resolved by appellate court. Should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail, subject to consent of the bondsman. If the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied of bail, or his bail shall be cancelled upon by the prosecution, with notice to the accused of the following or other similarities, other circumstances: A. That he is recidivist, quasi-recidivist, or habitual delinquent, or has committed a crime aggravated by the circumstances of reiteration. So, when we say recidivist, it is an individual who has history of repeated criminal offenses. And when we say quasi-recidivist, it is a term sometimes used to describe individuals who have not been previously convicted of crime but have engaged in behavior that is similar to criminal conduct. And lastly, when we say habitual delinquent, it is often used in the context of juvenile justice system. It refers to a young person who has not repeatedly engaged in delinquent or criminal behavior. So, it is important to note that precise definition and legal implication of these terms may depending on the jurisdiction and legal system in question. That's all.
Hello ma'am, I am John Mark Pipito and this is the continuation of our report. That he committed offense while under probation, parole or conditional pardon, that the circumstances of case indicate that probability of flight if released on bail, or E. that there is undue risk that he may commit another crime during the pendency of the appeal. And those are the factors that may affect his temporary release from jail. The appellate court may motu proprio or on motion of any review the resolution of regional trial court after a notice that the adverse party in their case. Corporate surety. Any domestic or foreign corporation licensed as a surety in accordance with the law and currently authorized to act such as may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by its board of directors. It provides a guarantee that executor or administrator will fulfill their duties in accordance with the law and event that they fail to do so. The surety company will provide financial compensation to the state and its beneficiaries. Next is posting a property bond. A property bond is undertaking constituted as lien on the real property given as security for the amount of the bail within 10 days after the approval of the bond. The accused shall cause the annotation of the lien on the certificate of title on file with the registry of deeds if the land is registered, or if unregistered, the registration book on the space provided, therefore, deeds for the city where the land lies, and on the corresponding tax declaration in the office of the provincial, city, and municipal assessor concerned. Within the same period, the accused should submit to the court of his compliance, and his failure to do so shall be sufficient cause the cancellation of the property bond and his rearrest detention. This means that a person pays a certain amount of cash with the city to guarantee that she or he will appear at the next court setting. If a person does not appear at the next setting, after posting a cash bond, the bond may be forfeited or lost or be deprived. Next is deposit of cash as bail. The accused or any acting in his behalf may deposit in cash with the nearest collector of internal revenue or provincial, city, or municipal treasurer the amount of bail fixed by the court, are recommended by the prosecutor who investigated or filed the case upon submission of a proper certificate of disposed and written undertaking showing the compliance with the requirements of Section 2 of this rule. The accused shall be discharged from custody. The money deposit shall be considered as bailed and applied to the payment of fine and cost while they exist, if any, shall be returned to the accused or to whoever made the deposit. You can deposit cash at the nearest collector of revenue or provincial, city, or municipal treasurer the amount of bail fixed by the court, and you will release from the custody, and they will return it to you or the one who deposit the existing money from the expenses. Next is forfeiture of bail. When the presence of accused is required by the court of this rule, bondsmen shall be notified to produce him from the court on a given date and time. If the accused fails to appear in a person as required, his bail shall be declared forfeited and bondsmen given 30 days within which to produce their principal and to show why no judgment should be rendered against from the amount of their bail. Within the said period, the bondsman must A. Produce the body of their principal or give the reason of non-production. B. Explain why the accused did not appear before the court when first required to do so. But don't worry if you didn't appear in the court or on the time that is required by the court, because if you have an attorney, they can argue with the judges of your non-appearance on the court. Next is cancellation of bail. Upon application of the bondsman, with due notice to the prosecutor of the bail may be cancelled upon surrender of the accused or proof of his death. The bail shall be deemed automatically cancelled upon acquittal of the accused, dismissal of case, or execution of judgment of conviction. In all instances, the cancellation shall be without prejudice to any liability on the bail. The bail may be cancelled upon surrender of the accused or proof of his death, or if the accused defendant is not found guilty of the crime. He has been accused, and he will be no longer responsible for that the court that has issued. Next is arrest of accused on bail. For the purpose of surrendering the accused, the bondsman may arrest him or upon written authority endorse on a certified copy of the undertaking, cause him to be arrested by a police officer or any other person of suitable age and discretion. An accused released on bail may be rearrested without necessity of a warrant if he attempts to depart from the Philippines without permission of the court where the case is pending. So, the bondsman may arrest the accused upon written authority endorsed on a certified copy of undertaking. A police officer or any person of suitable of age or discretion. At the accused is released on bail and may be rearrested if he attempts to leave the pending case that he is facing. Next is bail not a bar objection on illegal arrest, lack of irregular preliminary investigation. An application for admission to bail shall not bar the accused from challenging the validity of arrest or the legality of the warrant issued. Therefore, or from assailing from the regularity of questioning the absence of preliminary investigation to the charge against him, provided that he raises them before entering his plea. The court shall resolve the matter as early as practicable, but not later than the start of the trial. Arraignment and plea. A criminal proceeding at which defendant is officially called before a court of competent jurisdiction, informed of the offense charged in the complaint, information, indictment, or other charging document, and asked to enter a plea of guilty, not guilty or otherwise permitted by the law. Depending on the jurisdiction, arraignment may also be the proceeding at which the court determines whether to set bail for the defendant or release the defendant on his or her own recognizance. Arraignment means stating the charges against someone who is accused of a crime in a formal procedure by putting him in court. And plea means that states that the accused is not guilty or guilty for the crime. What is plea? It is a formal response by the defendant to affirmative assertion of the plaintiff in a civil case or to the charges of the prosecutor in the criminal case. Usually, a defendant's response to a criminal charge may either be guilty or not guilty. Arraignment and plea. Next is arraignment and plea. The accused must be arraigned before the court where the complaint or the information was filed or assigned from trial. The arraignment shall be made in the open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language of dialect known to him, and asking him whether he pleads guilty or not guilty. Prosecution may call the trial witnesses other than named in the complaint information. That's letter A. A means accused is given a copy of the complainant or information, which means asking him whether he pleads guilty or not guilty. Let's proceed to letter B. Letter B. The accused must be present at the arraignment and must be personally enter his plea. Both arraignment and plea should be made of record, but failure to do so shall not affect the validity of the proceedings. Both accused and complainant should be present and should be made of record, but failures of records will not affect the validity of the proceedings. Letter C. When the accused refuses to plead or make conditional plea, a plea of not guilty shall be entered to him. It means that you are informing the court that you deny guilt or you have a good defense in your case. Letter D. When the accused pleads guilty, both presents exculpatory evidence. His plea should be deemed withdrawn and plea of not guilty should be entered for him. It means that if you pleads guilty but you have a exculpatory evidence show plea of not guilty be entered to you. Example of this is the defendant is masculine and has a long hair, is charged with the robbery, and the video of robbery shows that the perpetrator is a skinny and bald. The video would be exculpatory because it negates the defendant's guilt. Let's proceed to letter E. When the accused is under preventive detention, his cases should be ruffled and his record should be transmitted to the judge to whom the case was ruffled within 3 days from the filing of the information or complaint. The accused should be arraigned within 10 days from the date of the ruffle. The pre-trial conference of his case should be held within 10 days after the arraignment. It means, and if the offended party failed to appear to the court, the court may allow to enter plea of guilty to lesser the offense, which means that the accused will have a lesser offense if he found guilty, only if he found guilty. G. Unless a shorter time is provided by special law or Supreme Court in circular, the arraignment shall be held within 30 days from the date the court acquired jurisdiction over the accused person, the time of the pendency of a motion to quash or for a bill of particular or other cause justifying suspension of the arraignment shall be excluded in the computing period. Here are some kinds of guilty plea. Letter A. Plea of guilty to a lesser offense. It is arraignment that the accused with the consent of the offended party, and prosecutor may be allowed the trial court to plead guilty to a lesser offense. Letter B. Plea of guilty to capital offense. Plea of guilty to capital offense, the court shall conduct a searching inquiry into voluntariness and full comprehension of the consequences of his plea and shall require the prosecution to prove his guilt and the precise degree of culpability. The accused may present evidence in his behalf. Letter C. Plea of guilty to non-capital offense. Reception of evidence discretionary. When the accused pleads guilty to non-capital offense, the court may receive evidence from the parties to determine the penalty to be imposed. And that's all to my part, ma'am, and thank you.
Hi, good day ma'am. I'm Christian Partosa and I will continue reporting about our topic, which is court pillar. Withdrawal of improvident plea of guilty. At any time, before the judgment of conviction becomes final, the court may permit an improvident plea of guilty to be withdrawn and be substituted by a plea of not guilty. At any time before the conviction becomes final, the court may allow an idealized guilty plea to be withdrawn and replaced with a not guilty of plea. What is the Alford Doctrine? The Alford Doctrine provides that a court may accept a knowing a voluntary plea of guilty from a defendant even though the defendant maintains his innocence, provided the trial judge determines that there is a factual basis for the plea. So, the Alford Doctrine provides that a court may accept a free conscious admission of guilt from a defendant even if the trial judge determines that there is a factual basis for the guilty plea. For example is a situation where the defendant has no recollection of the pertinent events due to amnesia. Motion to quash. A motion to quash is a request to a court to render a previous decision of the court or a lower judicial body null or invalid. It can arise out the mistakes made by any lawyer in the court proceeding. A lawyer may file a motion to quash if a mistakes have been on the part of the court or its attorney believes that the issuance of some court documents like a subpoena was not done in a legal manner. So a motion to quash is a motion to set aside, is a request to a court to reverse a previous decision. It can arise from mistakes made by a lawyer in a legal proceedings. An attorney can file a motion in the court made by mistake or if the issuance of certain judicial documents such as subpoena was not enforced in a lawful manner. Grounds for motion to quash. A. The facts charged do not constitute an offense. B. The court trying the case has no jurisdiction over the offense charged. C. The court trying the case has no jurisdiction over the person accused. D. That the officer who filed the information had no authority to do so. E. That it does not conform substantially to the prescribed form. F. That more than one offense is charged, except when a single punishment for a various offense is prescribed by the law. G. That a criminal action or liability has been extinguished. H. That it contains averments which, if true, would constitute a legal excuse jurisdiction. And I. That the accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express consent. So there are 9 grounds for filing motion to quash. If there is one or more are present of the 9 grounds, you can file a motion to quash. Arraignment and double jeopardy. Double jeopardy exists when accused has been convicted or acquitted or the case against him is dismissed or otherwise terminated without his express consent by a court or competent jurisdiction. Upon a valid complaint or information or other formal charge sufficient in form of substance to sustain a conviction, after the accused had pleaded to the charge, the conviction or acquittal of the accused of the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or it necessarily included in the offense charged in the former complaint or information. In short, double jeopardy refers to the rule that a person should not be tried twice for the same crime. Arraignment and double jeopardy is a person cannot be tried twice for the same crime based on the same conduct. For example, if a person robs a bank, that individual cannot twice be tried for robbery for the same offense. Retrial. Retrial refers to a proceeding held by a judge, arbitrator, etc. before a trial to clarify issuance of law and fact and stipulate certain matters between the parties. It also refers to a conference held before the trial begins to bring the parties together to outline discovery proceedings and to define the issuance to be tried. Pre-trial is a mandatory criminal case in all criminal cases cognizable by the Sandigang Bayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court and Municipal Circuit Trial Court. And court shall, after arraignment, it within 30 days from the date that court acquired jurisdiction over the person of the accused, unless a shorter period is provided for in special laws or circular of the Supreme Court, order a pre-trial conference to consider the following. So, pre-trial or preliminary investigation is mandatory in all criminal proceedings before the Sandigang Bayan, Regional Court, Metropolitan Court of First Instance and Municipal Court. Pre-trial refers to a conference held before the trial begins to bring the parties together, to outline discovery, procedures, and define the issuance to be addressed. A. Plea bargaining. Plea bargaining is a negotiated agreement between a criminal accused and a prosecutor where the accused agrees to plead guilty or no contest for a concession from a prosecutor in exchange for a plea. For example, Louis John is charged with the possession of illegal drugs with an intent to sell. He asks his lawyer to negotiate a plea bargain under which he will admit that he possessed the drugs in exchange for facing the lesser charge or simple possessions. B. Stipulation of facts. Stipulation of facts or judicial admission by the accused that witnesses is present will testify to certain facts stated in the affidavit of the prosecution was precisely in the nature of such a waiver. C. Making for identification of evidence of the parties. Making for identification evidence of the parties is a document or objects presented during a trial before there has been testimony which confirms their authenticity and or relevancy. D. Waiver of objections to admissibility of evidence. Waiver of objectives to admissibility of evidence is a grounds for objections not raised at the proper time shall be considered waived, even if the evidence was objected to on some other ground. E. Modification of the order of trial if the accused admits the charge but interposes a lawful defense. When the accused admits the acts or omission charged in the complaint or information but interposes a lawful defense, the order of trial may be modified. F. Such matter as will promote a fair expedition trial of the criminal and civil aspects of the case. If the accused has pleaded not guilty to the crime charged, he may state whether he interposes a negative or affirmative defense. Trial. Trial refers to the judicial examination of the issuance in a civil or criminal cause by a competent tribunal and determination of this issuance in accordance with the law in the land, if determination of an prosecution, and for the accused of the judicial examination of issues involved. So, trial means the judicial review of civil or criminal cases by a court of competent jurisdiction and the determination of those cases in accordance with the law of the land. This involves the establishment of the guilt or innocence for a defendant after hearing the testimony of the public prosecutor and the defendant and the judicial review of the facts in questions. Public attorney's duties where the accused is imprisoned. If the public attorney is assigned to defend a person charged with a crime knows that the latter is preventively detained, either because he is charged with a bailable crime but has no means to post bail, or is charged with a non-bailable crime, or is serving a term of imprisonment in any penal institution, it shall be his duty to do the following. Public attorney's duties is when the prosecutor charged with defending a person accused of a crime knows that the person is a pre-trial detention because he has no means to pay bail or is serving a prison sentence in a prison. The person is charged with a felony who may or may not be released on bail. So A. Shall promptly undertake to obtain the presence of the prisoner for trial or cause a notice to be served on the person having custody of the prisoner, requiring such a person to advise the prisoner of his right and demand trial. You will promptly obtain the detainee's presence for trial or have the person in custody of that detainee of his right and requesting a trial. The prisoner has the right to a trial. B. Upon receipt of the notice, the custodian of the prisoner shall promptly advise to the prisoner of the charge and of his right to demand trial. If at any time thereafter the prisoner informs his custodian that he demands such a trial, the latter shall cause notice to the effect to be sent promptly to the public attorney. The prisoner's guardian must inform the prisoner of the charges and of his right to request a trial. If at any time the prisoner informs his guardian that he is requesting such a procedure, the guardian must ensure that a notice to the effect is sent to the prosecutor. Letter C. Upon a receipt of such a notice, the public attorney shall promptly seek to obtain the presence of the prisoner for trial. The prosecutor must immediately requesting the presence of the detained of the hearing. Letter D. When the custodian of the prisoner receives from the public attorney a properly supported request for the availability of the prisoner for purpose of trial, the prisoner shall be made available accordingly. So when the prisoner's guardian receives a reasoned request from the public prosecutor to place the prisoner at the disposal of the prisoner is made available accordingly. Remedy where accused is not brought to trial within time limit. If the accused is not brought to trial within the time limit required, the information may be dismissed on motion of the accused on the ground of denial of his right to speedy trial. The accused shall have the burden of proving the motion, but the prosecution shall have the burden of going forward with the evidence to establish the exclusion of time. The dismissal shall be subject to the rules and double jeopardy. Failure of the accused to move for dismissal prior to trial shall constitute a waiver of the right to dismiss under the section. Remedy where the information may be withheld if the suspect is not brought to court within the required time frame. The dismissal is subject to the double jeopardy rules. The defendant's failure to request an acquittal before the trial constitutes a waiver of the right to be acquitted under his section. Order of trial. The trial shall proceed the following order. The prosecution shall present evidence to prove charge and in the proper case, the civil liability. The prosecution will provide evidence to support the charge and it, if applicable, civil liability. Letter B. The accused may present evidence to prove his defense and damages, if any, arising from the issuance of provisional remedy in the case. The defendant can present evidence to support his defense and any damages resulting from the issuance of an interim relief in the case. Letter C. The prosecution and the defense may, in the order, present rebuttal and surrebuttal evidence unless the court, the furtherance of justice, permits them to present additional evidence bearing upon the main issue. The prosecution and defense may present a rebuttal and supporting evidence if these orders, unless the court permits them, in the interest of justice, to present supporting evidence that relates to the main question. The court may also permit them to present other supporting evidence. Letter D. Upon the admission of evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda. The case is submitted to judgment upon admission of the parties' evidence. The parties are not required to plead orally or produce written memoranda unless the court orders them to do so. The case is then submitted to the court for the judgment to be handed down. E. When the accused admits the act of omission charged in the complaint or information but interposes a lawful defense, the order of trial may be modified. If the defendant admits the act or omission aligned in the complaint or information but present a legitimate defense, the order of the trial may be changed and the trial could be delayed until the defendant's defense has been presented. If the defendant is found guilty, the trial will continue as usual. That's all. Thank you, ma'am.
Application for examination of witness for accused before trial. When the accused has been held to answer for an offense, he may, upon motion with notice to the other party, have witnesses conditionally examined in his behalf. For the application of examination of witness for accused before trial, the motion shall state the name of the residence of the witness, the substance of his testimony, and that the witness is sick or infirm as to afford reasonable ground for believing that he will not be able to attend the trial, or resides more than 100 kilometers from the place of trial, has no means to attend the same, or that similar circumstances exist that would make him unavailable to or prevent him from attending the trial. The motion shall be supported by an affidavit of accused and such other evidence as the court may require. The trial of several accused. When two or more accused are jointly charged with an offense, they shall be tried jointly unless the court, in its discretion and upon motion of the prosecutor or any accused, orders separate trial for one or more accused. Trial of several accused. This is when one or more accused are jointly charged with an offense, they shall be tried jointly. Discharge of accused to be state witness. When two or more persons are jointly charged with the commission of any offense, upon motion of the prosecution before resting its case, the court may direct one or more of the accused to be discharged with their consent, so that they may be witnesses for the state when, after requiring the prosecution to hearing in support of the discharge, the court is satisfied that a. There is absolute necessity for the testimony of the accused whose discharge is requested. B. There is no direct evidence available for the proper prosecution of the offense committed, except the testimony of said accused. C. Testimony of said accused can be substantially corroborated in its material points. D. Said accused does not appear to be most guilty. E. Said accused has not at any time been convicted of any offense involving moral turpitude. Moral turpitude means an act or behavior that gravely violates the sentiment or accepted standard of the community. Evidence adduced in support of the discharge shall automatically form part of the trial. If the court denies the motion for discharge of the accused as state witness, his sworn statement shall be inadmissible in evidence. Discharge of accused to be state witness, it means that there is no other evidence to establish the offense other than the testimony of the accused. Discharge of accused operates as acquittal. The order indicate in the preceding section shall amount the acquittal of the discharged accused shall be a bar to future persecution for the same offense, unless the accused fails to or refuses to testify against his co-accused in accordance with his sworn statement constituting the basis for his discharge. Discharge of accused operates as acquittal. This means that the accused makes substantial changes in his testimony that would naturally affect the proceedings and would be prejudicial to the prosecution of the offense charged. When mistake has been made in charging proper offense, when it manifests at any time before the judgment that a mistake has been made in charging the proper offense, that accused cannot be convicted of the offense charged or any other offense necessarily included therein. The accused shall not be discharged if there appears good cause to detain him. In such case, the court shall commit the accused to answer for the proper offense and dismiss the original case upon the filing of the proper information. When mistake made in charging proper offense, the court shall dismiss the original complaint or information upon filing of a new one charging the proper offense. What is demurrer to evidence? Demurrer to evidence is an objection by one of the parties in an action to the effect of the evidence which is adversary produced is insufficient in the point of law, whether true or not, to make out the case or sustain the issue. After the prosecution rests its case, the court may dismiss the action on the ground of insufficiency of evidence, one, on its own initiative after giving the prosecution the opportunity to be heard, or number two, upon demurrer to evidence filed by the accused with or without leave of court. Demurrer to evidence. Example of demurrer to evidence is a finished presenting his evidence and said, "I now rest my case, Your Honor." What is the law of the case doctrine? The principles state that if the highest appellate of the court has been determined a legal question and returned the case to the court below for additional proceedings, the question will not be determined differently on a subsequent appeal in the same case where the facts remain the same. The law of the case expresses the rule of the final judgment of the highest court in the final determination of the rights of the party. The principle that an appellate court's decision on a legal issue is binding on both the trial court and remand and appellate court on a subsequent appeal in the same case with a substantially the same facts. Judgment. Judgment is defined as the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition of him of the proper penalty and civil liability of if any. Judgment must be A. Written in the official language, B. Personally and directly prepared by the judgment and signed by him, and C. Clearly and distinctly contained of a statement of the facts and the law upon which it is based. Contents of judgment. A legal qualification of offense constituted by the acts committed by accused and the aggravating or mitigating circumstances which attend its commission. B. The participation of the accused in the offense, whether the principal, accomplice, or accessory after the fact. C. The penalty imposed upon the accused. And D. The civil liability or damages caused by his wrongful act or omission to be recovered from the accused by the offended party. If there's any, unless of the enforcement of the civil liability by a separate civil action has been reserved or waived. In case of the judgment is of acquittal, it shall state whether the evidence of the prosecution absolute failed to prove the guilt of the accused or merely failed to prove his guilt beyond reasonable doubt. In either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. Promulgation of judgment. The judgment is promulgated by reading it in the presence of the accused and in any judge of the court in which it was rendered. However, if the conviction for a light offense, the judgment may be pronounced in the presence of his counsel or representative. When the judge is absent or outside of the province or city, the judgment may be promulgated by the clerk of the court. If accused is confined or detained in other province or city, the judgment may be promulgated by the executive judge of the regional trial court, having jurisdiction over the place of confinement or detention upon request of the court which rendered the judgment. The court promulgating the judgment shall have authority to accept the notice of appeal and the approved to bail bond pending appeal, provided that if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed when the resolved by an appellate court. The proper clerk of the court shall be given by the accused personally or through his bondsman or warden and counsel, requiring him to present the promulgation of the decision. If the accused was tried in absentia because he jumped bail or escaped from prison, the notice him shall be served as his last known address. Promulgation even the accused fails to appear in case the accused fails to appear at the scheduled date or promulgation of judgment despite notice. The promulgation shall be made by recording the judgment in the criminal docket and serving him a copy thereof at his last known address or through his counsel. If the judgment is for conviction and the failure of the accused be appear with was without justifiable cause, he shall lose the remedies available in these rules against the judgment and the court shall order his arrest within 15 days from promulgation of judgment. However, and the cause accused may surrender and file the motion for leave of the court to avail of these remedies. Modification of judgment. Modification of judgment. A judgment of conviction may, upon motion of the accused, be modified or set aside before it becomes final or before the appeal is perfected, except where the death penalty is imposed. A judgment becomes final the lapse of the period for perfecting an appeal, or where the sentence has been partially or totally satisfied or served, or when the accused has waived in writing his right to appeal or has applied for probation.
What is the doctrine of immutability of judgment? It is a fundamental legal principle that a decision that has acquired finality becomes immutable and unalterable and may no longer be modified in any respect, even if the modification is meant to correct erroneous conclusion of fact and law, and whether it be made by the court that rendered to any by the highest court of the land. The only exemption of the general rule on finality of judgment are so-called non-proton entries which cause no prejudice to any party, void judgment, and whether circumstances transpire after the finality of decision which render its execution unjust and inqualitable. The doctrine of immutability judgment, also known as the doctrine of finality judgment, is a legal principle that holds that a judgment or decisions rendered by the court in a particular case and a final cannot be altered or amended by that court except the very limited circumstances. What is a verdict? A verdict is popularly known as the outcome in a criminal case, particularly the point at which the defendant is either found guilty or not guilty of the crime. A verdict of guilty in a criminal case is generally followed by the judgment of conviction rendered by the judge, which in turn be followed by the sentencing, the new trial or reconsideration. The new trial refers to a repeat inquiry by the same court into all or some of the issues in the actions for the purpose of correction of a problem. In the prior trial, determining the merits of a challenge to the prior outcome, or considering newly discovered evidence, retrial of the case ordered by a higher court on the grounds of A. Judicial misconduct or misdirection of jury. B. Procedural defect or availability to fresh evidence. So, a verdict is a formal decision or finding a jury or a judge in a court of the law at the end of the trial hearing. It is the final outcome of the case that determines whether the accused is guilty or not guilty, or whether the plaintiff or defendant prevails in a civil case. The verdict can take various forms depending on the nature of the cause. So, for example, in a criminal case, and the verdict may be guilty or not guilty. Well, the civil case, The verdict may be for the plaintiff or for the defendant, and the verdict is typically recorded in the court or records and becomes part of the official records court. When motion for new trials or reconsideration be made at any time before a judgment of conviction becomes final, the court may, on motion of the accused or at its own instance but with the consent of the accused, grant a new trial or reconsideration. In general, a motion for a new trial or reconsideration must be made within a specific time frame after the entry of the judgment or verdict. The deadline for filing the motion for a new trial or reconsideration may vary depending on jurisdiction and the type of case. In many jurisdictions, the deadline for filing a motion for a new trial reconsideration is usually within a relatively short period of time after the entry of judgment. Often within 10 to 30 days, the specific deadline may be set by local courts rule by statute. The new grounds for a new trial. A. That errors of a law or irregularities prejudicial to the substantial rights of the accused have been committed during the trial. B. The new and material evidence has been discovered which the accused could not with reasonable diligence have discovered and produced at the trial, and which it's introduced and admitted would probably change the judgment. The ground for a new trial may vary depending on the jurisdiction and the type of the case involved, but generally a new trial may be granted if one of the following conditions is met. So first, the newly discovered evidence. If new evidence that was not known or available at that time of the original trials come, and the evidence could not have been discovered through reasonable diligence, a new trial may be granted. Second, insufficient evidence. If there was an insufficient evidence to support the verdict, a trial may be granted. Ground for reconsideration. The court shall grant reconsideration on the ground of errors of law or fact in the judgment, which requires no further proceeding. A motion of reconsideration is a request made to the court to reconsider its ruling and decision on a particular case. The ground for a motion for reconsideration may vary depending on the jurisdiction and the specific role of the court. But generally, a motion for reconsideration may be based on one more on the following grounds. First, the new evidence. If the evidence is discovered after the courts, the ruling that was not available or known to party at the time of the ruling, a motion for reconsideration may be filed. New evidence must be material and relevant to the issue that the court decided. Effect for granting a new trial or reconsideration. A. When the new trial is granted on the ground of errors of a law or irregularities committed during the trial, all the proceeding and the evidence affected thereby shall be set aside and taken anew. The court may, in the interest of justice, allow the introduction of additional evidence. B. When the new trial is granted on the group of newly discovered evidence, the evidence already added shall stand on the newly discovered and such as other evidence as the court may, in the interest of justice, allowed to be introduced shall be taken and considered together with the evidence already in the record. So the effect of granting a new trial or reconsideration may depending on the jurisdiction and the specific facts of the case. So, but generally, a new trial of reconsideration is granted with the original decision of justice may be vacant or set aside. The original decision of judgment may no longer be in effect of the parties may have to start over with the trial or hearing. In all cases, when the court grants new trial or reconsideration, the original judgment shall be set aside or vacated and the new judgment rendered accordingly. Appeal. Appeal refers to an act of asking higher courts to reverse the decision of a trial court after final judgment or other legal ruling. It is the process in which cases are reviewed, where parties request for a formal change to an official decision. Appeal functions both as a process for error correction as well as the process of clarifying and interpreting the law. Appeal is a legal process that allows the party to challenge the decision made by the lawyer, by a lawyer court or administrative agency. The parties appealing the decision is called the appellant, or the party defending the decision is called appeal. Who may appeal? Any party may appeal from a judgment of final order, lest the accused will be placed in double jeopardy. Where to appeal? The appeal may be taken as follows: to the RTC in cases decided by the METC or MTCC, MTC or MCTC, to the Court of Appeals or the Supreme Court in the proper cases provided by law, in cases decided by the Regional Trial Court, and to the Supreme Court in cases decided by a Court of Appeal. Effect of appeal by any several accused, an appeal taken by one or more the several accused shall not affect those who did not appeal insofar as the judgment of the appellate courts is favorable and applicable to the latter. The appeal of the offended party from the civil aspect shall not affect the criminal aspect of the judgment or order appeal from the lipon perfection of the appeal, the execution of the judgment of or final order appeal from shall be stayed as the appealing party. So the venue of the court or the court where an appeal should be filed depend on the type of case and the level of the court that issued a decision being appealed. So in the case decided by the lower courts, such as Municipal Trial Court or MTC and Metropolitan Trial Courts or METC, or Municipal Trial Courts in Cities or MTCC, the appeal is usually filed by the Regional Trial Courts or RTC in the same province or city where the lower courts is located. So the next one is appointment of a counsel de officio for accused on appeal. It shall be the day of the clerk of the trial court upon filing of a notice of appeal to ascertain from the appellant, if confined in prison, whether he desires the regional trial courts of appeals of the Supreme Court to appoint a counsel de officio to defend him and to transmit with the record on a firm to be preferred by the clerk of court of the appellate court a certificate of compliance with this duty and of the response of the affiliate to this inquiry. Note, the issuance of search warrants of warrant of arrest, protection of the rights to the accused during trial, bail arrangement on the plea, pre and trial judgment, new trial or reconsideration, and appeal are topics to be discussed completely in the subject criminal procedure and court testimony under the area of criminal law and jurisprudence. So in criminal cases, an accused who is indigent or has no means to hire a private lawyer may be entitled to the service of the counsel de officio, which is the court-appointed counsel when the accused decides to appeal a criminal conviction or sentence. The accused cannot afford to hire the private lawyer. The accused may apply for the appointment of counsel de officio for the appeal. The accused may file a motion for appointment of counsel de officio with the court that issued a decision being appealed. So the last one is, what is a miscarriage of justice or failure of justice? A miscarriage of also known as a failure of justice is when an actually innocent found guilty. It is the grossly unfair outcome in a judicial proceeding. A defendant is convicted despite of lack of evidence on an essential writ of miscarriage of justice is sometimes used to describe any wrongful conviction, even when the defendant may be guilty. For example, a reference of conviction which for a result of an unfair or dispute trial. So, a miscarriage of justice or a failure of first justice occurs when the innocent person is wrongly convicted of a crime is not given fair trial. It can also refer to the situation when a guilty verdict is reached due to unfair dispute. This can also have severe consequences for the accused and undermine public confidence in the justice system. The justice system should ensure that justice is served through fair and impartial trials, access the legal representation, protection of the rights of the accused, and the avenues for appeal and review. What is the hidden accident principle in criminal justice? It refers to the inability to detect wrongful conviction. The criminal justice system is characterized by accidents, false conviction, that typically remain undetected. The inability to detect these accidents translates into optimism on the part of policymakers that false conviction only occurs at a negligible rate. The hidden accident principle in criminal justice refers to the idea that wrongful conviction or false convictions are often undetected in criminal justice system. This creates a false sense of optimism among policymakers that false convictions are rare. In other words, the hidden accident principle suggests that there may be more wrongful conviction that we are aware of, as they are often difficult to detect. And that's all. Thank you.